and that kind of situation is not something that we want to prevail. So, I mean, as I said, facts are stubborn things, and they are designated as enemy combatants and will be treated as such during the period of combat.
Will the senator yield for a question?
Yeah.
My question would be, under the provisions, would it be possible that an American citizen then could be declared an enemy combatant and sent to Guantanamo Bay and detained indefinitely?
I think that as long as that individual, no matter who they are, if they pose a threat to the security of the United States of America, should not be allowed to continue that threat. And I think that's the majority of American public opinion, especially in light of the facts that I continue to repeat to the senator from Kentucky. 27% of detainees who were released got back in the fight and were responsible for the deaths of Americans. We need to take every step necessary to prevent that from happening. That's for the safety and security of the men and women who are out there putting their lives on the line in our armed services. Mr. President, I suggest the absence of a quorum, or yield the floor.
Mr. President, do I understand there is morning business time still pending?
The senator is correct.
I ask consent that all morning business time be yielded back unless there's a request on the floor.
If there is no objection, so ordered.
Thank you, Mr. President. I yield to the senator from Michigan.
Under the previous order, the Senate will resume consideration of S.1867, which the clerk will report.
Calendar number 230, S.1867, a bill to authorize appropriations for fiscal year 2012 for military activities of the Department of Defense and so forth and for other purposes.
take the oath.
Mr. President,
Senator from Michigan.
I would now ask unanimous consent that the time between now and 12:15 be equally divided between myself working with Senator McCain on in opposition to the Udall amendment and controlled by Senator Udall.
Without objection.
And I understand under the pending UC that Senator Udall is now to be recognized to offer his amendment.
Under the senator is correct. Under the previous order, the senator from Colorado is recognized.
Mr. President.
Senator from Colorado.
Thank you, Mr. President. I rise this morning to speak in favor of amendment number 1107. But first let me say that I know how hard Chairman Levin and Ranking Member McCain have worked to craft a Defense Authorization Act that provides our armed forces with the equipment, the services, and the support that they need to keep us safe. And I want to thank also my colleagues from the Armed Services Committee, a number of whom I see here on the floor this morning, for their diligence and their dedication to this important work. With that, let me turn to the amendment itself. And I wanted to start, Mr. President, by thanking the co-sponsors of the amendment. And they include the chairwoman of the Intelligence Committee, Senator Feinstein, the chairman of the Judiciary Committee, Senator Leahy, and our colleague, Senator Webb, former Secretary of the Navy, and someone I think we all respect when it comes to national security issues. And I also want to point out that this amendment is a bipartisan amendment. Senator Rand Paul joined as a co-sponsor this morning and gave, I think, a very compelling floor speech just a few minutes ago. Senators Wyden and Durbin have also recently co-sponsored the amendment. I want to recognize their leadership as well. So, Mr. President, again, let me turn to the amendment itself. A growing number of our colleagues have strong concerns about the detainee provisions in this bill. And at the heart of our concerns is the concern that we've not taken enough time to listen to our counterterrorism community and have not heeded the warnings of the Secretary of Defense, the Director of National Intelligence, and the Director of the FBI, who all oppose these provisions. Equally concerning, Mr. President, we have not had a single hearing on these detainee matters to fully understand the implications of our actions. My amendment would take out these provisions and give us in the Congress an opportunity to take a hard look at the needs of our counterterrorism professionals and respond in a measured way that reflects the input of those who are actually fighting our enemies. Specifically, the amendment would require that our defense, intelligence, and law enforcement agencies report to Congress with recommendations for any additional authorities or flexibility that they need in order to detain and prosecute terrorists. My amendment would then ask for hearings to be held so we can fully understand the views of relevant national security experts. In other words, Mr. President, I'm saying let's ask our dedicated men and women who are actually fighting to protect Americans what they actually need to keep us safe. This is a marked departure, in my opinion, from the current language in the bill, which was developed without hearings and seeks to make changes to the law that our national security professionals do not want and even oppose, as I pointed out. Like other challenging issues we face here in the United States Senate, we should identify the problem, hold hearings, gather input from those affected by our actions, and then seek to find the most prudent solution. Instead, we have language in the bill, while well-intended, of that there's no doubt, that was developed behind closed doors and is being moved rather quickly through our Congress. The Secretary of Defense is warning us that we may be making mistakes that will hurt our capacity to fight terrorism at home and abroad. The Director of National Intelligence is telling us that this language will create more problems than it solves. The Director of the FBI is telling Congress that these provisions will erect hurdles that make it more difficult for our law enforcement officials to collaborate in their effort to protect American citizens. And the President's national security staff is recommending a veto of the entire defense authorization bill if these provisions remain in the bill. Now, with this full spectrum of highly respected officials and top counterterrorism professionals warning Congress not to pass these provisions, we are being asked to reject their advice and pass them anyway, again without any hearings or further deliberation. I don't know what others think, but I don't think this is what the people in Colorado expect us to do, and it's not how I envision the Senate operating. The provisions would dramatically change broad counterterrorism efforts by requiring law enforcement officials to step aside and ask the Department of Defense to take on a new role they are not fully equipped for and do not want. And by taking away the flexible decision-making capacity of our national security team, by forcing the military to now act as police, judge, and jailer, these provisions could effectively rebuild walls between our military, law enforcement, and intelligence communities that we've spent a decade tearing down. The provisions that are in the bill, to me and many others, appear to require that the DoD shift significant resources away from their mission to serve on all fronts all over the world. And this has real consequences, Mr. President, because we have limited resources and limited manpower. And again, I just want to say I don't think we'd lose anything by taking a little bit more time to discuss and debate these provisions. But we could do real harm to our national security efforts by allowing this language to pass, and that's exactly what our highest-ranking national security officers are warning us against doing. Mr. President, you'll note I'm speaking in the broadest terms here, but I did want to speak to one particular area of concern, just to give viewers and my colleagues a sense of what we face. The provisions authorize the indefinite military detention of American citizens who are suspected of involvement in terrorism, even those captured here in our own country, in the United States, which I think should concern each and every one of us. These provisions could well represent an unprecedented threat to our constitutional liberties. So let me explain why I think that's the case. Look, I agree that if an American citizen joins al-Qaeda and takes up arms against the United States, that person should be subject to the same process as any other enemy combatant. But what is not clear is what we do with someone arrested in his home because of suspected terrorist ties. These detainee provisions would authorize that person's indefinite detention, but it misses a critical point. How do we know, Mr. President, how do we know that a citizen has committed these crimes unless they are tried and convicted? Do we really want to open the door to domestic military police powers and possibly deny U.S. citizens their due process rights? If we do, I think that's at least something that's very worthy of a hearing, and the American people should be made aware of the changes that would be forthcoming in the way we approach civil liberties. But since our counterterrorism officials are telling us these provisions are a mistake, I'm not willing to both potentially limit our fight against terrorism and simultaneously threaten the constitutional freedoms Americans hold dear. As I begin my remarks, Mr. President, I hope I projected my belief that we have a solemn obligation to pass the National Defense Authorization Act. But we also have a solemn obligation to make sure that those who are fighting the war on terror have the best, most flexible, most powerful tools possible. To be perfectly frank, I'm worried that these provisions will disrupt our ability to combat terrorism and inject untested legal ambiguity into our military's operations and detention practices. We will hear some of our colleagues tell you not to worry because the detainee provisions are designed not to hurt our counterterrorism efforts. We all know that the best laid plans can have unintended consequences. And while I'm sure the drafters of this language intended the provisions to be interpreted in a way that does not cause problems, the counterterrorism community disagrees and has outlined some very serious real-world concerns. Stating in the language that there will not be any adverse effects on national security doesn't make it so. These are not just words in a proposed law, and those that will be chartered to actually carry out these provisions are urging us to reject them. Shouldn't we listen to their serious concerns? Shouldn't we think twice about passing these provisions? I've not received a single phone call from a counterterrorism expert, a professional in the field, or a senior military official urging us to pass these provisions. We have heard a wide range of concerns expressed about the unintended consequences of enacting these detainee provisions, but not a single voice outside of Congress telling us that this will help us protect Americans or make us safer. And, Mr. President, in addition to our national security team who are urging us to oppose these provisions, other important voices are also asking us to stop, slow down, and consider them more thoroughly. The American Bar Association, the ACLU, the International Red Cross, the American Legion, and a number of other groups have also expressed a wide range of serious concerns. And again, I want to underline, although the language was crafted with the best of intentions, there are simply too many questions about the unintended consequences of these provisions to allow them to move forward without further input from national security experts through holding hearings and engaging in further debate. Mr. President, I'm privileged to be a member of the Armed Services Committee. I'm truly honored. And as I've implied, and I want to be explicit, I understand the importance of this bill. I understand what it does for our military, which is why in sum, what I'm going to propose with my amendment is that we pass the NDAA without these troubling provisions, but with a mechanism by which we can consider in depth what's proposed and at a later date include any applicable changes in the law. It's not only the right thing to do policy-wise, it may very well protect this bill from a veto. The clearest path towards giving our men and women in uniform the tools they need is to pass this amendment and then send a clean National Defense Authorization Act to the President. In the Statement of Administration Policy, the President says the following, and I should again mention in the Statement of Administration Policy there's a recommendation that the President veto the bill. Quote, we've spent 10 years since September 11, 2001 breaking down the walls between intelligence, military, and law enforcement professionals. Congress should not now rebuild those walls and unnecessarily make the job of preventing terrorist attacks more difficult. These are striking words. They should give us all pause as we face what seems to be a bit of a rush to pass these untested and legally controversial restrictions on our ability to prosecute terrorists. So, Mr. President, I want to begin to close and in so doing urge my colleagues to think about the precedent we would set by passing these provisions. We are being told that these detainee provisions are so important that we must pass them right away without a hearing or further deliberation. However, the Secretary of Defense at the same time, along with the Director of National Intelligence and the Director of the FBI, are all urging us to reject the provisions and take a closer look. Do we really want to neglect the advice of our trusted national security professionals? I can't think of another instance where we would rebuff those chartered with keeping us safe. If we in the Congress want to constrain the military and give our service members new responsibilities, as these provisions would do, I believe we ought to listen to what the Secretary of Defense has had to say about it. Secretary Panetta is strongly opposed to these changes. And I think we all know that before he held the job he has now, Secretary of Defense Mr. Panetta was the director of the CIA. He very well knows the threats facing our country, and he knows we cannot afford to make any mistakes when it comes to keeping our citizens right. We have to be right every time. The bad guys only have to be right once. So this is the debate we need to have. It's a healthy debate, but we ought to be armed with all of the facts and expertise before we move forward. The least we can do is to take our time, be diligent, and hear from those who will be affected by these new significant changes in how we interrogate and prosecute terrorists. So as I've said before, it concerns me that we would tell our national security leadership, a bipartisan national security leadership, by the way, that we would not listen to them and that Congress knows better than they do. It doesn't strike me that that's the best way to secure and protect the American people. That's why I filed amendment number 1107. I think my amendment is a common-sense alternative that will protect our constitutional principles and beliefs while continuing to keep our nation safe. The amendment has a clear aim, which is to ensure we follow a thorough process and hear all views before rushing forward with new laws that could be harmful to our national security. It's straightforward, it's common sense, and I urge my colleagues to support the amendment. President, I thank you for your attention. I yield the floor.
Mr. President.
Who yields time? Senator from Michigan.
We have approximately a half hour on each side. I'm wondering how much Senator Graham needs.
10 minutes. Is that too much? 5 minutes?
Could you do 5 minutes?
7.
We have, I think, 7 speakers on this side.
Okay, I'll try to be quick.
Try to do 8 minutes. Would that be all right?
Yeah, I'll try to do it as quick as I can.
You'll make me have on this.
Okay.
We've had plenty of, just a long time from the sponsor of the bill, the chief opponent. We're going to have 10 minutes from the senator from Illinois. I yield the senator from South Carolina 10 minutes.
The senator from Arizona will control, if this is all right with the senator, half of our time. That be all right?
Without objection.
Well, thank you. Can you let me know when 5 minutes has passed, because there are a lot of voices to be heard on this issue, and I want them to be heard. I'm just one. And let me just start with my good friend from Colorado. I respect you. I know your concerns. I just don't agree. I can remember being told by the Bush administration we don't need the Detainee Treatment Act. Everybody said we didn't need it, but they were wrong. I remember being told by the Vice President's office during the Bush administration it's okay to take classified evidence, show it to the jury, the finder of fact, and not share it with the accused, but you can show it to his lawyer. How would you like an American soldier tried in a foreign land where they're sitting there in the chair wondering what the jury is talking about, can't even comment to their own lawyer about the allegations against them? I've been down this road with administrations, and we worked in a bipartisan fashion to change some things the Bush administration wanted to do, and I'm glad we did. And we're working in a bipartisan fashion to change some things this administration is doing, and I hope we're successful, because if we fail, we're all going to be worse for it. Here are the facts. Under this provision of mandatory military custody for someone captured in the United States, if you're an American citizen, that provision does not apply to you. But here's the law of the land right now. If you're an American citizen suspected of being joined al-Qaeda, being a member of al-Qaeda, you can be held as an enemy combatant. The Padilla case in South Carolina, where the man was held for 5 years as an enemy combatant, went to the Fourth Circuit Court of Appeals, and here's what the court said. You can interrogate that person in an intelligence-gathering situation. The only thing you have to do is provide them a lawyer for their habeas appeal review. So here's the due process rights. If our intelligence community, military believe that an American citizen is suspected of being a member of al-Qaeda, the law of the land as it is today, an American citizen can be held as an enemy combatant and questioned about what role you play in helping al-Qaeda, and you do get due process. Everybody held as an enemy combatant here at Guantanamo Bay, captured in the United States, goes before a federal judge, and the government has to prove by preponderance of the evidence that the person is in fact an enemy combatant. There is due process. We just don't hold someone and say, good luck. You have to go before a judge, a federal court, and prove your case as the government. And here's the question for the country. Is it okay to hold an American citizen who's suspected of helping al-Qaeda under military control? You better believe it's okay. Now, my good friend from Colorado said this repeals the Posse Comitatus Act. The Posse Comitatus Act is a prohibition on our military being used for law enforcement functions, and it goes back to Reconstruction. This is the central difference between us. I don't believe fighting al-Qaeda is a law enforcement function. I believe our military should be deeply involved in fighting these guys, at home and abroad. And the idea somehow allowing our military to hold someone captured in the United States is a repeal of the Posse Comitatus Act, you'd have to conclude that you view that as a law enforcement function where the military has no reason or a right to be there. That's the big difference between us. I don't want to criminalize the war. To Senator Levin, thank you for helping us this time around craft a bipartisan solution to a very real problem. The enemy is all over the world, here at home, And when people take up arms against the United States and captured within the United States, why should we not be able to use our military and intelligence community to question that person as to what they know about enemy activity? And the only way you can do that is hold them in military custody, and this provision can be waived. It doesn't apply to American citizens. But the idea that an American citizen helping al-Qaeda doesn't get due process is just a lie. You go before a federal court, and the government has to prove that you are part of al-Qaeda. And let me ask this to my colleagues on the other side. What if the judge agrees with the military or the intelligence community making the case? Are you going to require us to shut down the intelligence gathering process, read them their rights, and put them in federal court? That's exactly what you want. And that will destroy our ability to make us safe. If an American citizen is held by the intelligence community, the military, and a federal judge agrees that they are in fact a part of the enemy force, that American citizen should be interrogated to find out what they know about the enemy in a lawful way, and you should not require this country to criminalize what is an act of war against the people of the United States. They should not be read their Miranda rights. They should not be given a lawyer. They should be held humanely in military custody and interrogated about why they joined al-Qaeda and what they were going to do to all of us. So this provision not only is necessary to deal with real-world events, it is written in the most flexible way possible. And to this administration, the reason we're here on the floor today, it was your idea to take Khalid Sheikh Mohammed and put him in New York City and give him the rights of an American citizen and criminalize the war by taking the mastermind of 9/11 and making it a crime, not an act of war. So,
Senator has spoken for 5 minutes.
Thank you. I will wrap up. So to Senator Levin and Senator McCain, what they're accusing you of doing is not true. You're codifying a process that will allow us to intelligently and rationally deal with people who are part of al-Qaeda, not political distance. If you don't like President Obama, we're not going to arrest you. And I'm getting phone calls about, that's a bunch of garbage. You can say anything you want about the president or me. You just can't join al-Qaeda and expect to be treated as if it were a common crime. When you join al-Qaeda, you haven't joined the mafia. You're not joining a gang. You're joining people who are bent on our destruction and who are a military threat. And if you don't believe they're a military threat, vote for Senator Udall. If you believe al-Qaeda represents a threat to us at home and abroad, give our intelligence and military agencies statutory guidance and authority to do things that need to be clear rather than uncertain. We're 10 years into this war. Congress needs to speak. This is your chance to speak. I am speaking today. Here's what I'm saying to my colleagues on the other side and to the world at large. If you join al-Qaeda, you suffer the consequences of being killed or captured. If you're an American citizen and you betray your country, you're going to be held in military custody and you're going to be questioned about what you know. You're not going to be given a lawyer if our national security interests dictate that you not be given a lawyer and go into the criminal justice system, because we're not fighting a crime, we're fighting a war. There's more due process in this bill than any other time in any other war. I am proud of the work product. There are checks and balances in this bill that have been working on for 10 years. The mandatory provisions do not apply to American citizens. They can be waived if they impede an investigation. We're trying to provide tools and clarity that have been missing for 10 years. This is your chance to speak on the central issue 10 years after the war, the attacks of 9/11. Are we at war or are we fighting a crime? I believe we're at war, and the due process rights associated with war are in abundance and beyond anything ever known in any other war. What this amendment does, it destroys the central concept that we're trying to present to the body and to the country, that we're facing an enemy, not a common criminal organization who will do anything and everything possible to destroy our way of life. Let's give our law enforcement and military community the clarity they've been seeking, and I think now they will have. And to the administration, with all due respect, you have engaged in one episode after another to run away from the fact that we're fighting a war, not a crime. When the Bush administration tried to pass policies that undercut our ability to fight this war and attain our values, maintain our values, I pushed back. I'm not asking any more of the people on the other side than I ask of myself. When the Bush administration asked me and others to do things that I thought undercut our values, I said no. Now you've got an opportunity to tell this administration, we respect your input, but what we're trying to do needs to be done, not for just this time, but for the future. Ladies and gentlemen, either we're going to fight this war to win it and keep us safe, or we're going to lose the concept that there's a difference between taking up arms against the United States and being a common criminal. In conclusion, Khalid Sheikh Mohammed and all those who buy into what he's selling present a threat to us far different than any common criminal, and our laws should reflect that. Senator Levin and McCain, you've created a legal system for the first time in 10 years that recognizes we're fighting a war within our values. I hope we get a strong bipartisan vote for the tools in this bill. With that, I yield.
Mr. President,
The senator from Colorado.
how much time do we have remaining?
The senator has 15.5 minutes.
Okay. Before I recognize Senator Durbin for 8 minutes, I want to just respond to my friend from South Carolina, the senator from South Carolina.
Question, how much time on this side?
5 minutes remaining.
Senator from South Carolina is broadly admired in the United States Senate. If I'm ever in court, I want him to be my lawyer. I would point out, however, that what I'm proposing wouldn't destroy the system that we have in place, a system, by the way, that's resulted in the convictions of numerous terrorists with life sentences. What I am asking is to listen to those who are on the front lines of fighting against terrorists and terrorism, who've said they have concerns about this new proposal and would like a greater amount of time to vet it and consider it. I'd like to yield to the senator from Illinois, 8 minutes.
Mr. President, I just have unanimous consent requests, which Senator Durbin said I could interrupt him to make. I have 2 unanimous consent requests for committees to meet today. During today's session of the Senate, the approval of the majority and minority leaders, and I ask unanimous consent these requests be agreed to and that these requests be printed in the record.
Is there objection? Without objection.
Mr. President.
The senator from Illinois.
Mr. President, I have the greatest respect for Senator Carl Levin, Senator John McCain. They've done an extraordinary job on the Defense Authorization Bill. And I would say that, by and large, this bill would not have engendered the controversy that brings us to the floor today but for this provision, because it is a critically important provision which has drawn the attention not just of those in the military community, which they, of course, would expect in a defense authorization bill, but also the attention of those in the intelligence community and the law enforcement community across the United States, as well as the President of the United States. The provision which they include in this bill is a substantial and dramatic departure in American law when it comes to fighting terrorism. I salute Senator Udall for bringing it to the attention of the committee and now to the floor, that before we take this step forward, we should reflect and pass the Udall Amendment, which calls for the necessary agencies of government, law enforcement, intelligence, and military, to reflect on the impact of this decision, not just on the impact on America's security, but on America's commitment to constitutional principles. This is a fundamental issue which is being raised here, and it should be considered ever so seriously. And we need to ask ourselves why, 10 years after 9/11, are we prepared to engage in a rewrite of the laws on fighting terrorism? Thank God we meet in this chamber today with no repeat of 9/11. Through President George W. Bush and President Barack Obama, America has been safe. Yes, there are people that threaten us, and they always will. But we have risen to that challenge with the best military in the world, with effective law enforcement, and without giving away our basic values and principles as Americans. Take a look at the provision in this bill which Senator Udall is addressing. Who opposes this provision? I'll tell you who opposes it. Secretary of Defense Leon Panetta, who passed out of this chamber with a 100-0 vote of confidence in his leadership, has told us, don't do this. This is a mistake in this provision. Secondly, the law enforcement community, from Attorney General Eric Holder to the Director of the Federal Bureau of Investigation, have told us this is a mistake to pass this measure, to limit our ability to fight terrorism. And the intelligence community as well. The Director of National Intelligence tells us this is a mistake. So is it any wonder that Senator Udall comes to the floor and others join him from both sides of the aisle saying before you make this serious change in policy in America, ask ourselves, have we considered the impact this will have on our nation's security, our ability to interrogate witnesses, and our commitment to constitutional principles? When I take a look at the letter that was sent to us by the Director of the Federal Bureau of Investigation, Robert Mueller, I have to reflect on the fact that Director Mueller was appointed by President George W. Bush and reappointed by President Barack Obama. I respect him very much. He has warned the Senate, do not pass this provision in the Defense Authorization Bill. It may adversely impact, and I quote, our ability to continue ongoing international terrorism investigation. If this provision had been offered by a Democrat under Republican George W. Bush, the critics would have come to the floor and said, how could you possibly tie the hands of the President when he is trying to keep America safe? The Director of the Federal Bureau of Investigation has made it clear that the passage of this provision in this bill will limit the flexibility of the administration to combat terrorism. It'll create uncertainty for law enforcement, intelligence, and defense officials regarding how to handle suspected terrorists and raise serious constitutional concerns. Listen, all of those things are worthy of debate. Were it not for the record that for 10 years America has been safe. It has been safe because of a Republican president and a Democratic president using the forces at hand to keep us safe. If we were coming here with some record of failure when it comes to keeping America safe, it's one thing. But we have a record of positive success. And this notion that there is no way to keep America safe without military tribunals and commissions defies logic and defies experience. Since 9/11, over 300 suspected terrorists have been successfully prosecuted in Article III criminal courts in America. Yes, they've been read their Miranda rights, and yes, they have been prosecuted and sent to prison. The most recent being the underwear bomber who pled guilty just weeks ago in the Article III criminal courts. During the same period of time, when it comes to military commissions and tribunals, how many alleged terrorists have been convicted? 6. The score, my friends, if you're paying attention, is 300 to 6. President Bush and President Obama used our Article III criminal courts effectively to keep America safe, and in those instances where they felt military tribunals could do it best, they turned to them with some success. And I might add to those who want to just change the law again when it comes to military tribunals. This is the third try. Twice we have tried to write the language on military tribunals and commissions. It's been sent ultimately across the street to the Supreme Court and rejected. They told us start over. Do we want to risk that again? Do we want to jeopardize the prosecution of an alleged terrorist because we want to test out a new legal and constitutional theory? I hope not. I ask unanimous consent that the letter from the Director of the FBI made part of the record in the congressional record.
Without objection.
Let me also say, Section 1031 of this bill is one that definitely needs to be changed, if not eliminated. It will, for the first time in the history of the United States of America, authorize the indefinite detention of American citizens in the United States. I have spoken to the chairman of the committee, who said he is open to language that would try to protect us from that outcome. But the language as written in the bill, unfortunately, will allow for the indefinite detention of American citizens for the first time. The administration takes this seriously. We should too. They have said they'll veto the bill without changes in this particular provision. I hope that we will step back and look at a record of success in keeping America safe and not try to reinvent our Constitution on the floor of the United States Senate. I think we ought to give to every president, Democrat and Republican, all the tools and all the weapons they need to keep America safe. Tying their hands on the floor of the United States Senate may give us some satisfaction for a moment, but it won't keep America safe. I reserve the balance of my time.
Senator from Michigan.
President, I yield myself 10 minutes.
Without objection.
Time on our side. There have been so many misstatements of fact that have been made, it's hard to keep up with them. But let me just take the last statement that the senator from Illinois made about changing military tribunal law. There is no change in military tribunal law whatsoever, which is made in this bill. Now, I'm going to address the other misstatements that have been made by my friends and colleagues, but that one's the most recent, so I want to just take on that one first. Now, in terms of constitutional provisions, the ultimate authority on the Constitution of the United States is the Supreme Court of the United States. And here's what they have said in the Hamdi case about the issue which both our friends have raised about American citizens being subject to the law of war. A citizen, the Supreme Court said in 2004, no less than an alien, can be part of supporting forces hostile to the United States and engaged in armed conflict against the United States. Such a citizen, referring to an American citizen, if released, would pose the same threat of returning to the front during the ongoing conflict. And here's the bottom line for the Supreme Court. And if we just take this one line out of this whole debate, it would be a breath of fresh air to cut through some of the words that have been used here this morning. One line: there is no bar to this nation's holding one of its own citizens as an enemy combatant. Okay? That's not me. That's not Senator Graham. That's not Senator McCain. That's the Supreme Court of the United States. Recently, there is no bar to this nation's holding one of its own citizens as an enemy combatant.
Does Senator yield for a question?
I'd rather not at this point. Now, there's a number of sections in this bill. My dear friend Senator Udall says these sections, as though there's a whole bunch of sections which are at issue. There's really only one section which is at issue here, and that's Section 1032. And that's the so-called mandatory detention section that has a waiver in it. Section 1031 was written and approved by the administration. Okay? Section 1031, which my friend from Illinois has just said is an abomination, was written and approved by the administration. Now, Section 1031 is the authorities section. This authorizes. It doesn't mandate anything with the waiver that 1032 does. Section 1031, and now I'm going to use the word in the administration's own so-called SAP, or Statement of Administration Policy. This is what the administration says about Section 1031. The authorities codified in this section already exist. So they don't think it's necessary, 1031. But they don't object to it. Their words. The authorities in 1031 already exist, and they do. What this does is incorporate already existing authorities from Section 1031. Unnecessary in the view of the administration, yeah, but they helped write it and they approved it. We made changes in it. We've made so many changes in this language to satisfy the administration. I think it all comes down to one section, 1032. 1032 is the issue. Not all the sections, by the way, which would be stricken by the Udall Amendment. The Udall Amendment would strike all the sections, but it really comes down to Section 1032. And 1032 is the so-called mandatory provision, which, by the way, does not apply to American citizens. I better say that over again. Senator Graham said it, but let me say it over again. The most controversial provision, probably the only one in this bill, is Section 1032.
Section 1032 says that the requirement to detain a person in military custody under this section does not extend to citizens of the United States. I guess that's the second thing that I'd like for colleagues to take away from what I say, is that Section, and Senator Graham said the same thing, Section 1032, the mandatory section that has the waiver in it, does not, by its own words, apply to citizens of the United States. It has a waiver provision in it to make this flexible. And the way in which 1032 operates is that it says that if it's determined that a person is a member of al-Qaeda, then that person will be held in military detention. They are at war with us, folks. Al-Qaeda is at war with us. They brought that war to our shores. This isn't just a foreign war. They brought that war to our shores on 9/11. They are at war with us. The Supreme Court said, and I'm going to read these words again, there is no bar to this nation's holding one of its own citizens as an enemy combatant. They brought this war to us, and if it's determined that even an American citizen is a member of al-Qaeda, then you can apply the law of war, according to the Supreme Court. That's not according to the Armed Services Committee, our bill, or any one of us. That's the Supreme Court speaking. Who determines it? What we say, to give the administration the flexibility that they want, the administration makes that determination. The procedures to make that determination. Who writes those procedures? We don't write them. By explicitly, the executive branch writes those procedures. Can those procedures interfere with an ongoing interrogation or investigation? No. By our own language, it says they shall not interfere with interrogation or intelligence gathering. That's all in here. The only way this could interfere with an operation of the executive branch is if they decided to interfere themselves in their own operation. They're given explicitly the authority to write the procedures. I think we ought to debate about what is in the bill. And what is in the bill is very different from what our colleagues who support the Udall Amendment have described. Yes, we are at war, and yes, we should codify how we handle detention. And this is an effort to do that. And as the administration says itself, we are not changing anything here in terms of Section 1031. We are simply codifying existing law. The issue really relates to 1032. And that's what we ought to debate. Should somebody, when it's been determined by procedures adopted by the executive branch, been determined to be a member of an enemy force who has come to this nation or is in this nation to attack us as a member of a foreign enemy, should that person be treated according to the laws of war? And the answer is yes. But should flexibility be in here so the administration can provide a waiver even in that case? Yes. And finally, about civilian trials. I happen to agree with my friend from Illinois, and he is a dear friend of mine. Civilian trials work. There's nothing in this provision that says civilian trials won't be used, even if it's determined that somebody's a member of al-Qaeda. Not only doesn't it prevent civilian trials from being used, we explicitly provide that civilian trials are available in all cases. It's written right in here. I happen to like civilian trials a lot, participated in a lot of them, and they're very appropriate. And we have a very good record. In the case that you mentioned, the Senator from Illinois mentioned, excuse me, that case was a Michigan case. I know a lot about that case. It was the right way to go. I prefer civilian trials in many, many cases. This bill doesn't say that we're going to be using military commissions in lieu of civilian trials. That is a decision which we leave where it belongs, in the executive branch. But we do one thing in this bill in Section 1031, which needs to be said. We are at war with al-Qaeda, and people determined to be part of al-Qaeda should be treated as people who are at war with us. But even with that statement, we give the administration a waiver. That's how much flexibility we give to the executive branch. How much time have I used, Mr. President?
Senator has 3.5 minutes remaining.
I yield the floor.
President, how much time remaining on both sides?
Senator from Arizona has just over 5 minutes.
And
Senator from Colorado has 8 minutes.
President.
Senator from Colorado.
President, I just want to clarify for the record, before I recognize Senator Webb for 5 minutes, that some here claim that the Supreme Court's Hamdi decision upheld the indefinite detention of U.S. citizens captured in the United States. It did no such thing. Hamdi was captured in Afghanistan, not the United States. And Justice O'Connor, the author of the opinion, was very careful to say that the Hamdi decision was limited to, quote, individuals who fought against the United States in Afghanistan as part of the Taliban. End of quote. I think that's important to be included in the record. Let me yield to Senator Webb for 5 minutes.
Senator from Virginia.
Thank you, Mr. President. I'd like to say that I believe that the senator from Colorado has a good point here, and I say that as someone who is a strong supporter of military commissions, who in many cases has aligned myself with my good friend, the senator from South Carolina, and Senator McCain as well on these issues. To me, this is not a jurisdictional issue, and it's not an issue about whether we should be holding people under military commissions under the right cases or under military detention under the right cases. My difficulty, and the reason that I support what Senator Udall is doing, is in the statutory language itself. I say this as someone who spent a number of years drafting this kind of legislation as a committee counsel. I have gone back over the last 2 days again and again reading these sections against each other, 1031, 1032 particularly, and I'm very concerned about how this language would be interpreted, not in the here and now as we see the stability that we brought to our country since 9/11, but if something were to happen, and we would be under more of a sense of national emergency, and this language would be interpreted for broader action. And the reason that I have this concern is that we're really talking here about the conditions under which our military would be sent into action inside our own borders. And in that type of situation, we need to be very clear, and we must very narrowly define how they would be used, and quite frankly, if they should be used at all inside our borders. And I think that's the concern that we are hearing from people like the Director of the FBI and the Secretary of Defense. And I'm also very concerned about the notion of the protection of our own citizens and our legal residents from military action inside our own country. I think these protections should be very clearly stated. And in this language, there's a lot of vagueness. And what the senator from Colorado is proposing is that we clarify these concepts, that we take this provision out, clarify the concepts. Protections are in place in our country. We're not leaving our country vulnerable. In fact, I think we're going to make it a much more healthy legal system if we do clarify these provisions. So that is the reason I'm here on the floor to support what Senator Udall is saying, and I know the emotion and the energy that Senator Levin has put into this, and I respect him greatly. I just happen to believe that we should do a better job of clarifying our language. And I spent 16 years on and off writing in Hollywood, and one of the things that came to me when I was comparing this is kind of the danger that you get when you get the fourth or the fifth screenwriter involved in a story. You tend to want to fix one thing and you're not fixing the whole thing. And I greatly respect the legitimacy of the effort that is put into this, but when you read Section 1031 against Section 1032, there are questions about what would happen to American citizens under an emergency. Let's take, for instance, what happened in this country after Hurricane Katrina. It's not a direct parallel, but you can see the extremes that people went to under a feeling of emergency and vulnerability. We had people who were deputized as U.S. Marshals in New Orleans, and you could see them on CNN putting rifles inside people's cars, stopping them on the street, going into people's houses, making a decision that later was rescinded that they're going to take people's guns away from them. The vagueness in a lot of this language will not guarantee against these types of conduct on a larger scale if a situation were more difficult and dangerous than it is today. Section 1031, which Senator Levin mentioned, may be clear from the administration. It's not that clear to me when they talk about a covered person. This isn't simply al-Qaeda, depending on how you want to interpret it in a time of a national emergency. It says a person who was a part of or substantially supported al-Qaeda, the Taliban, or associated forces that are engaged in hostilities against the United States or its coalition partners, including any person who's committed a belligerent act. We might be able to agree what that means here on the Senate floor today, but you don't know how that might be interpreted in a time of national emergency. I'm not I'm not predicting that it will. I'm saying we should have the certainty that it will not.
The senator has consumed 5 minutes.
Okay. Similar